Comments.
Thank you. Mr. Rosenstein, when you appointed a special counsel on May 17th, you stated, quote, based upon the unique circumstances, the public interest requires me to place this investigation under the authority of a person who exercises a degree of independence from the normal chain of command. The order you issued along with that statement provides that 28 CFR 600.4 through 10 were applicable. Those are otherwise known as the special counsel regulations. Is that correct?
Yes, Senator.
And it states that the special counsel, quote, shall not be subject to the day-to-day supervision of any official of the department. However, the regulations permit you, as acting attorney general for this matter, to override Director Mueller's investigative and prosecutorial decisions under specified circumstances. Is that correct?
Yes, Senator.
And it also provides that you may fire or remove Director Mueller under specified circumstances. Is that correct?
Yes.
And you indicated in your statement that you chose a person who exercises a degree of independence, not full independence from the normal chain of command. So my question is this. In December of 2003, then Attorney General John Ashcroft recused himself from the investigation into the leak that led to the disclosure of Valerie Plame's identity as a CIA officer. The acting Attorney General at the time was Jim Comey. He appointed a special counsel, Patrick Fitzgerald, to take over the matter. In a letter dated December 30th of 2003, Mr. Comey wrote the following to Mr. Fitzgerald, quote, I direct you to exercise the authority as special counsel independent of the supervision or control of any officer of the department. In a subsequent letter, dated February 6, 2004, Mr. Comey wrote to clarify the earlier letter, stating that his delegation of authority to Mr. Fitzgerald was, quote, plenary. Moreover, it said that my, quote, conferral on you of the title of special counsel in this matter should not be misunderstood to suggest that your position and authorities are defined or limited by 28 CFR Part 600. Those are the special counsel regulations we discussed. So, would you agree, Mr. Rosenstein, to provide a letter to Director Mueller, similarly, providing that Director Mueller has the authority as special counsel, quote, independent of the supervision or control of any officer of the department, and ensure that Director Mueller has the authority that is plenary and not, quote, defined or limited by the special counsel regulations?
Well, Senator, I'm very sensitive about time, and I'd like to have a very lengthy conversation and explain that all to you. I tried to do that.
Can you give me a yes or no answer,
in the closed briefing? Well, it's not a short answer, Senator. The answer
it is either you are willing to do that or not, as we have precedent in that regard.
But
Mr. Chairman, they should be allowed to answer the question.
It's a long question you pose, Senator, and I fully appreciate the import of your question, and I'll get to the answer. My quibble with you is Pat Fitzgerald is a very principled, very independent person. I have a lot of respect for him. Pat Fitzgerald could have been fired by the President because he was a United States attorney. Robert Mueller cannot, because he's protected by those special counsel regulations. So although it's theoretically true that there are circumstances where he could be removed by the acting attorney general, which for this case at this time is me, your assurance of his independence is Robert Mueller's integrity and Andy McCabe's integrity and my integrity and those regulations.
Sir, if I may, the greater assurance is not that you and I believe in Director Mueller's integrity, which I have no question about Mr. Mueller's integrity. It is that you would put in writing an indication based on your authority as the acting attorney general that he has full independence in regards to the investigations that are before him. Are you willing or are you not willing to give him the authority to be fully independent of your ability statutorily and legally to fire him?
He has the
yes or no, sir?
He has the full independence that is authorized by those regulations. And
are
Senator,
you willing to do as has been done before?
Would the senator suspend? The chair is going to exercise its right to allow the witnesses to answer the question, and the committee is on notice to provide the witnesses the courtesy, which has not been extended all the way across, extend the courtesy for questions to get answered.
Mr. Chairman, respecsplically,
Mr. Rosenstein,
I would point out that this witness has joked with as we all have,
the senator
ability
will
to filibuster.
Mr. Rosenstein, would you like to thoroughly answer the question?
Thank you, Mr. Chairman. Senator, I'm not joking. The truth is, I have a lot of experience with these issues, and I could speak to you for a very long time about it. And I'm sympathetic. I appreciate the 5-minute limit. That's not my limit. But the answer is, this originated, as you may know, with the independent counsel statute. And I worked for an independent counsel, and I worked in the department during the independent counsel era when independent counsels were appointed by authorization of the Senate. They were appointed by federal judges, and they had essentially the authority equivalent to the Attorney General. That statute sunsetted, and the majority of members of this body concluded that that was appropriate because they did not want special independent counsels who were 100% independent of the Department of Justice. That was a determination made by the legislature. Now, I know the folks at the department who drafted this regulation under Janet Reno, and they drafted it to deal with this type of circumstance. And the idea was that there would be some circumstances where, because of unusual events, it was appropriate to appoint somebody from outside the department, not somebody like Pat Fitzgerald, who was a U.S. attorney who could be fired, but somebody from outside the department who could be trusted to conduct this investigation independently and could be given an appropriate degree of independence. Under the regulation, he has, I believe, adequate authority to conduct this investigation. And your ultimate check, Senator, is, number one, the integrity of the people involved in the investigation. But number two, the fact that if he were overruled or if he were fired, we would be required under the regulation to report to the Congress. And so I believe that's an appropriate check. And so while I realize that theoretically anybody could be fired, and so there's a potential for undermining an investigation, I am confident, Senator, that Director Mueller, Mr. McCabe, and I and anybody else who may fill those positions in the future will protect the integrity of that investigation. That's my commitment to you, and that's the guarantee that you and the American people have.
Senator
So
Cornyn.
is that a no?
Senator Cornyn.
Well, seems to be one thing we all agree on, at least so far based on the questions and the comments, and that is the 702 is an important tool for the intelligence community and one that needs to be preserved. And I agree with Senator Cotton that it should be extended without a sunset provision as currently written. So it's good to have one thing we agree on. But I want to ask Director Coates and perhaps Admiral Rogers if you want to comment on this as well. As I understand the framework of 702, it is to intentionally not target American citizens. It is to intentionally target foreign persons and to not collect information from American citizens except by way of incidental collection. And I think you've described, Admiral Rogers, the extensive procedures that the law requires and that NSA practices have in place to minimize the access of anybody in the intelligence community to that U.S. person. And indeed, you've talked about purging incidental collection that was made in the course of a 702 investigation. So it strikes me, Director Coates, the question that Senator Wyden has asked you and that's come up several times, to intentionally target American citizens in order to generate a number is just the opposite of what the structure of 702 provides, because the whole idea is to not collect, not to be able to gather information about American citizens except in the incidental course of collecting information against a foreign intelligence target. Is that a fair statement?
That's fair in my mind, and it was a central piece of the information of fact that caused me to come to the conclusion that this would do just exactly what you said. You're breaching someone's privacy to determine whether or not they are an American person.
To generate a list for Congress.
It potentially could, yes, yeah, to generate a list for Congress. That wasn't the only basis on which we made the decision, but that was an essential basis. Thank you.
I want to ask a little bit more about the minimization procedures and the importance of those, and a little bit about unmasking of U.S. persons' names that Admiral Rogers and others have, Director Coates, you've talked about. You've explained the process and the elaborate procedures that are in place to make sure that this is not done accidentally or casually. And I think that's very important to reassuring the American people that in the collection of foreign intelligence, we are extraordinarily protective of the privacy of U.S. citizens who might be incidentally collected against. And so, to me, the minimization procedures are very important. The internal policies of the NSA when it comes to collecting foreign intelligence that happens to incidentally impact American citizens is absolutely critical to this balance between security and individual privacy. Perhaps this is a question for Mr. Rosenstein, though, and maybe Director McCabe. If someone is to use the unmasking process for a political purpose, is that potentially a crime?
Yes, Senator.
And Director McCabe, perhaps, or Deputy Attorney General Rosenstein, for somebody to leak the name of an American citizen that is unmasked in the course of incidental collection, to leak that classified information, is that also potentially a crime?
Yes, I think that's the most significant point, Senator. I think it's important for people to understand unmasking is done in the course of ordinary legitimate intelligence gathering, when the identity of the person on the other end of the phone, the other end of the message, may be relevant to understand the intelligence significance of the communication. Leaking is a completely different matter. Leaking is a crime. Disclosing information to somebody without a legitimate purpose, need to know that information, that will be prosecuted in appropriate circumstances. And there have been cases where we've been able to determine there's a willful violation of federal law, a disclosure that was not authorized, and prosecutions have been brought and will be brought.
And Mr. Rosenstein, not to pick on you or Director McCabe, but I think there's some confusion when we talk about generically about Russian investigations. We've described the role of the special counsel, which I think you've discussed in great detail, but that's primarily to investigate potential criminal acts and counterintelligence activities. Is it not?
The answer to that is yes. It is the idea of the Russian investigation that has much broader significance, I know, to many of you than the piece that Director McCabe and I are referring to, and the piece that Director Mueller is investigating.
Well, that's enormously helpful, at least to me, because when people speak generically of the Russian investigation, I think they're also including things like our responsibilities, the Intelligence Committee, to do oversight of the intelligence and of the potential countermeasures we might undertake to deal with the active measures campaign of the Russian government, which were clearly documented in the intelligence community assessment. But by my count, there are multiple committees of the United States Senate, including the Judiciary Committee on which I serve, which has different jurisdiction and oversight responsibilities. It's our job to do the investigation and write legislation. We're not the FBI. We're not the special counsel. We're not the Department of Justice. And I'm afraid in the conversation that we've been having here, people have been conflating all of those, and those are very distinct and importantly distinct functions. Thank you.
Senator Reid.